We just can wait few minutes for the judge to connect.
Good morning.
Good morning, sir.
Yeah, Judge Omar Mheiri is with you.
Good morning, Judge Omar. I'll start by reading out a statement first, if you don't mind.
Yeah, please.
Yes. The hearing on this matter is being held by way of teleconference. Any orders or directions made after or during the course of this hearing will be issued by the Registry in Dubai on His Excellency Justice Omar al-Mheiri's instruction. The hearing today is in the matter of CFI 083-2018 before His Excellency Justice Omar al-Mheiri. The claimant is a litigant in person represented by Dwela. The defendant is a litigant in person represented by Julian Delange.
Thank you, Mehta. Yes, the procedure for today's hearing, I'm going to hear the defendant and then the claimant, then the reply from the defendant. So I have the whole view about the merits of the case. So we'll focus only on the one matter, the limitation, with the 6 years argument.
Thank you, sir.
The claimant with me?
Yes, Your Honor.
Okay. So then I think will not exceed more than one and a half hour. I think this is much more than enough to each part express his view on this argument. If the defendant success in his argument, then the case will be dismissed. If he failed, then the second case management will going on. And allow both parties to file evidence and fix a case management conference later on. It's clear?
Thank you. It's very clear.
Sir.
Yeah. So then, defendant, please start.
Yes, good morning, sir. My name is Julian Delange, and I appear on behalf of Damac Park Towers Company Limited. On 28 May, I filed a skeleton argument. Have you had an opportunity to read and consider that yet, sir?
Yes, as I said earlier, I have opportunity to look at the whole correspondence between both parties.
Okay, that's very helpful. Thank you. I'll keep this brief then, because I agree that this is something that could be dealt with quite promptly. I'm on page 3 of my skeleton, if you consider it helpful to follow me.
Yes,
but in brief, for the purposes of limitation, Rule 7.5 of the DIFC Court Rules provides that the starting date is the date on which the claim form is filed. In this case, it's a matter of record that date is 17 December 2018. So if we just take a pragmatic approach to the 6-year limitation, the date that we are concerned with today is what the claimant / respondent in this case knew as at 17 December 2012. That's simply 6 years prior to this date. And for completeness, I just want to draw everyone's attention to 2 laws, 2 DIFC laws. The first is Article 123 of Law Number 6. That's Bundle 12 in my bundle, document 12 in my bundle, and it says within 6 years after the cause of action has accrued, and a cause of action accrues when the breach occurs, regardless of the aggrieved party's lack of knowledge. So in this case, the purported breach, and I stress that it's strongly denied by the applicant that there is any breach, but the purported breach alleged against us is that the unit in question was constructed too small. Now, that is a breach, if it is in fact a breach, that would have occurred at the time of construction and long before the scheduled handing over period. And the reason I make this point is because the handing over period, the handing over notice, the first one was on 5 January 2012, and that automatically falls outside of the 6-year limitation period. So even if that was the first time the breach occurred, which is denied, I would submit that that breach occurred when the building was being constructed. But let's just take the 5 January. Even on that interpretation alone, the case is time barred. For completeness, the one exception to this is in the case of fraud. Now again, I stress that the applicant certainly did not act fraudulently, but even in that case, the 6-year period commences not at the time of the breach, regardless of knowledge. It commences at the date the party discovered the breach. That is the earliest point that the respondent in these proceedings learnt the size of the unit. Now, I submit, for the reasons set out in my skeleton arguments, that that again is well outside the 6-year limitation period. Even if we take the latest point that is on the record, and that is the latest, I point out, that is an email from my client dated 29 November 2012. That is outside the 6-year limitation period. Moving back, there is a statement of account dated 11 April 2012 setting out the correct area, and that is even further outside of the 6-year limitation period. So, sir, in a nutshell, my case is that these proceedings are time barred. The dates in question are a matter of public record, and they are in fact agreed to by the respondent in its written applications, in its skeleton arguments. It's not controversial.
Mm-hmm. Yeah, I'm with you. Go ahead.
Thank you. If you have any further questions, if you'd like me to elaborate, I'm more than happy to. I'm trying to keep this brief.
Until finish. When you finish, if I have some question, of course, I will ask you. Because I don't want to wasting the time, you know. We calling.
Yes, of course.
Yeah.
I will say one more thing with the greatest of respect to my friend. I'm afraid this is a situation, and without getting into the merits, where the respondent didn't understand how the size of the unit was calculated. And I don't want to get drawn into this, but although I do sympathise with that, the plaintiff is a commercial investor. And the first thing you do when you're entering into a commercial investment opportunity is you review the contract and make sure that is very clear. All of the correspondence submitted by my client, with the exception of one simple mistake, which was promptly corrected, and that simple mistake was the size of the unit on 5 January. That error was immediately corrected. A refund was issued to my friend.
What you refer to the first handover letter?
Yes, sir. That's dated 5 January. That informed Mr. Dwela that the unit will be ready for handover on the 30th of January. Now, that incorrectly recorded the size of the unit, which we accept. So we promptly issued another letter in February saying, we're sorry, there was a mistake. This is the actual size of the unit, which is still in accordance with the contract. But because of the size, we've issued a refund to you, and a credit was issued against his account. This is all outside the 6-year limitation period. So I'm cautious to get into this because this is all before.
Okay. Did Mr. Dwela receive his refund or not?
Yes, he did, sir. And the document that records that is document 4 in the bundle. And if you go to the second page, towards the bottom, you'll see a credit dated 31 December 2011. The description is area variation, and you'll see a debit to the account of 310,787 dirhams and 20 fils.
Okay.
That was credited to Mr. Dwela on account of the variation. And I should say that that variation was in accordance with the terms of the contract and certainly did not constitute
Are you aware that Mr. Dwela appoint an expert, a third party, to investigate regarding the size point?
I only learnt that when I received his written response a couple of days ago.
Okay. Do you have any comments on this report? Or do you have a chance to read it?
So 2 points. One is I haven't seen it and I haven't read it. But what I will do is draw the court and Mr. Dwela's attention to the terms of the SPA that deal with the unit size.
Mm-hmm.
So the relevant clause in the SPA is 10.10. And I am conscious that we're going into the merits here, sir, but I will be very brief because the matter has been raised. Clause 10.10 deals with that. Now,
Okay.
the size on the SPA on the front page, as is accepted by my friend, is 2402.53 square feet. We agree with that. That is the total area, and there are in fact two areas that are relevant in this case should it go to a merits hearing, and one is the total area and the other is the net unit area. The total area as built is 2136.63 square feet, and the net area as built is 1588.44 square feet. Now, those two measurements have been consistently recorded throughout the correspondence from day one, except for that one letter that I mentioned that we promptly recorded, dated 5 January 2012. Where the confusion is coming from is in the SPA, only one area is mentioned, and that is the total area. So what we have is a comparison of 2402.53 total area as recorded in the SPA, and the as-built total area, which is 2136.63. There is a slight variation, and that variation was compensated in the credit to Mr. Dwela's account. But again, so all of this takes place outside of the 6-year limitation period. So our position, if I may extend, is these proceedings are time barred. But even if they weren't time barred, Mr. Dwela simply can't succeed on the merits of this. This is taking up both parties' time, the court's time, and taking up the parties and the court's costs. And that's all I have for now, sir, unless you have any further questions.
No. Thank you.
Thank you.
Yeah, Mr. Dwela, are you with us?
Hi, yes, Your Honor, I'm here.
Yeah, go ahead.
So first of all, I would like to say that unfortunately, I'm defending my dad here, Mr. Salem Dwela, who is unable to be with us today as he's having connection problems to join. He's actually, at the moment, he's in Italy, and unfortunately, he will not be with us today. So I will just, defend him.
So did he authorize you to do that?
Yes, I have submitted to the registry all the documentations regarding to that.
Okay. Any objection from the defendant? The defendant, are you with me? Any objection?
Sir, I haven't seen the documentation, but I have no objection, sir.
Okay. So your name, you said Walid Dwela?
My name is Walid Dwela. Yes, I'm the son.
Okay, go ahead. I'm listening.
Okay, so there's a lot of things that has been touched by Mr. Julian, but I would like to focus first because this is what Your Honor wanted to do, to focus on the time limitations for raising the objection. So as per DIFC court rules, the defendant who wished to do so will do it will dispute the court's jurisdiction to try to claim or argue that the court should not exercise its jurisdiction, may apply to the court for an order declaring that that it has no such jurisdiction or should not exercise any jurisdiction which it may have. Then there's another ruling which says a defendant who files an acknowledgement of service does not, by doing so, lose any right that he may have to dispute the court jurisdiction. And again, an application under this part must be made within 14 days after filing an acknowledgement of service.
But the application before me, not a dispute in jurisdiction. This is what the defendant said. You don't have, the court has no power to interfere in this case because the time bar is already passed.
Yes, and to that I have my objection. First of all, is when did the alleged breach occur? So
Okay.
whether the claim
now you're on right track.
Okay, perfect. Thank you for letting me know that. So we can say that the alleged breach, in fact, occurred on June 2013, as I stated on the defense, when the claimant actually viewed the unit, and only then the discrepancy of the unit was discovered as a result of the fraudulent, what we believe is fraudulent action by the defendant. So is not 5th of January 2012, as Mr. Julian determined in its statement of defense. Therefore, the 6-year period from the date of the alleged breach concludes on June 2019. So the defendant made fraudulent misrepresentation to the claimant with respect to the stage of the construction, the time taken for the completion of the unit, the location of the unit as well, and also the lack of pool view that it was. We were told that the unit would have a view over the pool, but most importantly, the unacceptable difference in the size of the unit, which is 34%. So what Mr. Julian said, we still need to ascertain exactly what is the difference in size as well, because as we have called an external surveyor, the difference seems to be 34% difference in size. So it's not the size that Mr. Julian was claiming there. So there is a DFC law, which is the Law of Obligation 2005, DFC Law 5 of 2005, Article 9, which provides where a cause of action arises as a result of fraud by the defendant, there is no time limit before which the action must be commenced. It then first states that a cause of action arises on the earliest date on which the claimant knows or ought reasonably to know about the loss that gives rise to the cause of action. Provides that any action is brought within 15 years of the date that the cause of action in fact arose. Then also we stated on our defense the case of Mr. Kishan Chand Gangaram Bhatia versus ICC Bank Limited in the AFC, which basically we pointed to some extracts from the judgment, which shows the interpretation of Article 123 of the FC Law 6 of 2004. Let me just read that. Give me 1 second.
Take your time.
Yeah. The language of must not be commenced in Article 38 of the court law is found also in Article 9 of the obligations law. It is similarly found in Article 123, 1 of the contract law 2004, DFC law number 6 of 2004, which provides that an action of breach of any contract must be commenced within 6 years after the cause of action has accrued. But then in the Limitation Act 1980 of England and Wales, the language is that an action should not be brought after the expiration of a time period analogous language of no action shall be brought and may not bring action is used in other provisions. In relation to the language, it is well established that the expiry of the period bars the remedy, the action, and does not extinguish the right. I have provided that on our defense, but basically the main thing to take here is that in accordance with Article 123 of DFC Law 6 of 2004, just give me 1 second here.
It's okay.
Just give me 1 second.
Take your time. Mr. Julian,
yeah.
Are you with us?
Yes, sir.
Yeah.
So also on the 5th of January 2012 here, as we stated, the defendant had issued the notice of completion to the claimant, thereby confirming that the handover would commence on the 30th of January 2012. On different occasions, the claimant was intimated regarding the different size of the unit. The statements of account dated on the 5th of January 2012 from Damac, in which the unit area was mentioned as 972 square foot. So we had different statements of account, not only once, but we had throughout the years and throughout we had several accounts as to what the unit was. So that falls into definitely something which which we believe might be fraudulent, because we have been seeing all different types of statements at different times. So on the 23rd of February 2012, another notice was sent by the defendant for notice of completion and possession, informing that the claimant about the errors in the calculation of the unit areas. This notice included the statements of account from Damac, in which the unit area was mentioned as 2,402.53 square feet. Later, on the 11th of April 2012, another statement of account was issued portraying the size for 2,136.63 square feet. Further to that, on 24 April 2012, the claimant intimated the defendant via email and telephone, pointing that there was a smaller, that the area was smaller than the one that we agreed on the SPA, and the location was different. Then it was on the 29th of November 2012 when the defendant replied to the claimant by email, affirming that there is this discrepancy in the size from the total area as sold, and they believed it to be 2,136 and 63, and that's what Mr. Julian was referring to, I believe. Then on 2nd of December 2012, the claimant sent a reminder to the defendant to provide the documentation for the unit as agreed, in order to enable the claimant to ascertain the size and related matters to the unit. But the claimant failed to receive any response from the defendant, and then approached the AFC on the 6th of January 2013 by email, requesting for the drawings related to the property. Then again in 2013, the claimant was demanded to sign the handover of the unit in spite of not having seen the unit. And on April 17, 2013, and June the 27th, 2013, the claimant followed up with the defendant for the requested clarification and documentation for the size of the unit. So there has been several, requests from our side, to ascertain the size of the unit, and that was never possible. And we had very misleading information as to what the size of the unit was until our legal representatives, DWF, agreed with Damac to send an external surveyor and actually measure the unit. And what Mr. Julian was referring to in terms of the net area of the unit, there is actually a clause on the SPA which says the net floor area of the unit is measured for the exterior facts of the exterior walls and from the center lines of the common walls joining two units and across internal walls. For the if the permitted use of the unit is office, then the total area of the office unit includes, for the purpose of calculation of the purchase price only, the party of the common office area which is attributable to the unit as described in clause 1.1. And also what Mr. Julian said is that we received a refund. We never received any refund. And also the actual size of the unit that he's describing is not the right size of the unit. So we have got an external surveyor that established that the actual unit that we actually got was 34% less than what we should than what it was agreed on the SPA. So that would, so it's not usable for its purpose as an office. So, there's another clause in the SPA which says if the final measurement of the unit is smaller than the measurement represented to the purchaser, then the purchase price for the property will be decreased. If the difference is more than 5%, we're talking about 34%. And that has never been provided by a refund has never been provided by Damac. And then again, even if a refund was provided to us, we're saying that the a unit is not fit for its purpose, which was an office, because it's way too small. It doesn't have any daylight. It's below the swimming pool podium. It's completely dark. It's completely unfit for the purpose that we actually agreed on the contract. So. This is the reason why we believe that the defendant should refund us the money for the unit, because it's completely, they say that the unit was delivered in a timely manner, which actually was delivered 12 months after, but that is stipulated in the contract that they're allowed to do so. But until now, we haven't received the unit as we requested it, which is the unit that we have agreed for in the SPA for 2,400 and plus square feet. We still haven't received that. So there's really a lot of disparity in the figures that we have been reporting, and this leads to misleading statements. Also, we had to pay the registration fees for the unit as it was sold to us for 2,400 and plus square feet, which, if Damac was aware that there was a discrepancy from the beginning, why were we allowed to pay the registration fees for that amount? Why didn't they inform us throughout the, if the unit was already available, because they told us there was just cladding work that needed to do at the time of signing the contract? Why, and I have proof of that, I have emails of that. Why they did not inform us of the size, if at the time of signing the contract they already knew which plot they were going to allocate? So this is, in terms of that, and to respond to Mr. Julian. So the MAC failed to provide any basic information. They didn't want to show us the title deed. They didn't want to tell us really what was the measurement of the unit, and so for this reason, we believe that their decision to strike out the case is baseless, because basically there is a breach of the contract that occurred on their side. And as per DFC Law 7 of 2005, Article 22, a cause of action arises when the breach occurs, regardless of the aggrieved party's lack of knowledge of the breach, except where the breach constitutes or is combined with fraud, in which event a cause of action arises when the aggrieved party discovers the breach. So this is exactly what we're arguing. We're arguing that the MAC was aware of this from the onset, from the very beginning, was aware of the difference in size, was aware that it was not overlooking the swimming pool, that the apartment, that the unit was going to be below the swimming pool podium, and so that constitutes that constitutes one, a breach of contract, and then there's also an element of fraud here. So this is what we're disputing. And to go back what Mr. Julian said, we have not until now received any credit back. We haven't received any acknowledgement of the exact size. Well, we're still in dispute as to what the real size is, because we have proof now from an independent external surveyor of the size, but it doesn't seem that the MAC is taking that into account. In fact, Mr. Julian said he didn't even see the survey, which to me is very strange, because like we have actually agreed with Damac to bring this surveyor, and that was shared with the MAC, and that was part of the reason why the MAC came to the table in December and wanted to agree on something else, on another apartment, a commercial apartment, to make up for for that. So
December which year?
of 2019.
19. Yeah. And the surveyor, which date or which year you appoint that surveyor?
That was in October 2019.
Okay. And why you keep waiting until 2018 to file a case?
Okay, so this is the thing. We have been in several negotiations with the MAC. We have been we have actually sought legal representations through different lawyers, and for some reason it never worked out, as in they would start the proceeding, they would collect information, they will review all the information, and then they will say we either own there was one instance of some lawyers that then went to work for the MAC. There was some instance of a lawyer that says, well, we cannot proceed with your case because the lawyer actually left the company that was following your case, and so we went to at least.
And this incident happened in 2018 or before?
What? Sorry, Your Honor. Which incident?
The scenario which you described about the lawyer when you were trying to appoint the
No,
lawyer.
that was well before. That was in 2016. We started actually, consulting lawyers. Even before that, we started consulting lawyers from very soon, like from.
Okay.
When
Any notice sent from the previous lawyers to Damac at that date or before that date?
Yes, we have plenty of correspondence from our lawyers and legal representatives to Damac. I can provide.
Can you provide that, because it's not before me and the documents
okay.
here.
Okay, sure. I will provide that. I have many correspondences from our legal representatives who got in touch with Damac and tried to actually get into negotiations and to try to understand the size and try to settle this in an amicable way. So this goes back several years. So I can definitely provide that that with you, Your Honor.
And copy defendant, please.
And copy the defendant, of course. So I will send it to the registrars and copy Mr. Julian on those emails for sure. Yes.
Okay. So, are you done, or still you have something to submit? I think you cover the points, all points which
yes.
in
Yes,
skeleton
Your Honor.
argument you cover. Yes, Mr. Julian.
Yes, sir. I just very briefly have 7 points to raise in response, if that's okay.
Yes, okay. Go ahead.
I'll keep these very brief and succinct. The first is easy, and that's to do with the court's jurisdiction. So we certainly do not dispute that the court has jurisdiction to determine this matter. That's dealt with at paragraph 6.1 of my skeleton argument. And sir, I can also draw your attention to the governing law of the SPA, which clearly says the courts have jurisdiction, and that is clause 19. So just to nip that one in the butt. So you do have jurisdiction, and in fact, we're relying on your jurisdiction to strike these proceedings out. So that's the first point. The second point, I think I'll deal with this next, is to do with the settlement proceedings and the claimant's engagement of lawyers. So we have always sought to try and amicably settle this dispute. 100%. We have no issue. We want our customers, our purchasers, to be happy, and if we can help them, we certainly will. Now, the claimant has engaged, at least since a formal claim was lodged, and I only raise this because it was raised by my friend. They have engaged at least 2 law firms since a formal claim was submitted to the court.
So what you're saying, what you're saying is after 2018, not before.
Correct. So if my friend was unhappy with any issue, they can write a letter to us, and we'll try to amicably settle that. And you're right, that there probably is a lot of letters. This was before my time at Damac, but there probably is a lot of letters. But just for the current purposes of this legal issue here, after a claim was submitted, that is after 17 December 2018, the claimant has gone through at least 2 sets of lawyers. Now, as my claimant has said, and I only raise this because he has, what those lawyers would do is review all the documents and then for some reason not continue to act. And with respect, the best course of action was to settle this amicably because there is no merit. This claim is so obviously time-barred. And I mean this with the greatest respect. I do sympathise. And even though we knew it was time-barred, we still tried to settle this. I do sympathise. But as a matter of law, this case is clearly time-barred. So I wanted to raise that because I think that is very important. We should not be criticised for trying to settle this, even though it's time-barred. Unfortunately, that did not work. So that was my second point. The third is in relation to my friend's comment that he did not, quote, discover the size of the unit until June 2013 when his father actually came to Dubai from Italy. Now, 2 things. For a start, he's admitting that that's not the date that time should start because that is the date he, quote, discovered it. Now, secondly, that's wrong. I mean, you can discover things by looking at something and making a judgment call, or you can read the correspondence and understand that. So I do object to that. And my third point on that is, with respect, I suspect that that's where this misunderstanding has happened. We've had a purchaser who's purchased a unit, they're based in Italy, they haven't been involved, they don't know how it's worked. Perhaps he didn't read it as carefully as he should, perhaps he should have got a lawyer to read it. I can't comment on that. But even today, he's not here in Dubai. And I do admit, of course, that the current COVID situation makes that even more difficult, but I think that really goes to the misunderstanding point I made earlier. The next point I'll make, sir, is in relation to fraud. Now, I've dealt with the allegation of fraud at paragraph 5.1 of my skeleton argument, and with respect, I object in the strongest terms to my client being accused of acting fraudulently. That's simply not true. And I will raise the court's attention to Law number 5 of 2005, which is document 14 in my bundle, which actually provides some guidance on what constitutes fraud. Fraud is when a statement is said that is known to be false, or if we had no belief in its truth, or we acted recklessly. And it cannot be said that the conduct of my client constituted any of those three elements. My client has always, with the exception of the one letter on 5 January 2012, which was a mistake and was corrected promptly, has always recorded the correct size of the unit. And on that point, that is my next point, so is the actual size. And I just want to repeat, there are two ways that the size of the unit is measured. One is the total area, and the second is the net area. And what I suggest is Mr. Dwela has focused on the net area. So in the SPA, the net area was not recorded, only the total area was recorded. And I've referred the court to the provisions in the contract that deal with that distinction.
Yeah.
So in the SPA, we have the total area of 2402.53. The actual as-built area is smaller, and I accept that. It is 2136.63, which is about 11%, 10%, 11% smaller than we had anticipated. And I use the words in the contract. Now, because it's finished, we can also tell you what the net area is, and that is 1588.44. I just repeat, I think this really goes to a misunderstanding on Mr. Dwela's part, and I do mean that with the greatest respect. So the next point I'll raise, and I only have two more. The next point is in relation to the refund and the credit. Mm-hmm. It's important to remember how these things work. As Mr. Dwela has said, he has to pay certain amounts once you own a property. So we maintain a statement of account. That is in document 4 in the bundle. And as you can see, it is a matter of written record that a credit was issued. That we certainly don't write checks and send those, if that's what Mr. Dwela was alluding to when he said he didn't receive the money, but he certainly did, and that's a matter of written record, and I have no further point on that. Mm-hmm. The final point, and again, this one can be dealt with quickly, is Mr. Dwela mentioned the unit was not, quote, fit for purpose. Fitness for purpose is a legal term, a construction term that does not apply to this SPA. Again, what I suggest is Mr. Dwela's purpose was in his mind as to what he had hoped to achieve with the unit, which I cannot comment on, and my client cannot be held accountable for. My client entered into an SPA. It provided the unit in accordance with that SPA. It provided a credit as a result of the reduction in the size of that SPA. It delivered on time in accordance with the terms of the SPA. We have complied with the SPA, but what we unfortunately do have, and again it goes back to my amicable settlement point, we have a situation where one of our purchasers has bought something without knowing what they're buying, and we wanted to try and assist them and provide them with another unit, and those discussions didn't eventuate into anything. But just to finally finish, this case is time barred. It's time barred on any interpretation of the law and of the written facts that we all agree with. So regardless of the merits, I'm afraid the claimant, and he said he's engaged at least 2 law firms and law firms before this, even in those circumstances, he didn't commence the proceedings. I say that's either 1, not our fault, and regardless of the reason, or 2, it's because the law firms that he engaged perhaps came to the same conclusion. And so unless you have any questions, that's all I have.
No, thank you. So then I will give you a chance to reply on the claimant submission. which regarding the previous lawyers which his father appointed before 2018. Then I'm going to reserve the case for judgment. Regarding the cost, actually, when writing my judgment, I will consider the cost as a general rules. Who win the case, he will reward the cost. Otherwise, if you think I shall give you on a further submission after issuing my handing down my judgment to discuss the cost, I don't mind. With the consideration that the claimant is a litigant person.
Yes. Sir, I'm happy to do one of two things. One is file a formal cost submission setting out the time involved, or two, perhaps me and Mr. Dwela can have a conversation, and if there is an issue as to costs, we can maybe come to an agreement. As I say, I do appreciate the situation that you've raised, and he is a litigant in person.
It's okay. Then, when handing down my judgment, I will decide on the cost, and I will give you a chance to file a further submission on that.
Thank you.
Okay. Thank you for.
Thank you, Your Honor.
Yeah. Thank you for hearing today, and I try to handing down my judgment within 3 weeks from today. If I need if I need any assist from both of you, definitely the registry will contact you through emails.
Thank you very much. Thank you, Your Honor.
Thank you.
Thank you, sir.
Bye bye.
Stay safe. Thank you.
Bye.
You too.